My name's Fidan. I'm a family law solicitor practicing in Sydney, Australia, and today I'm going to talk to you about a case of the Appeals Court of the Federal Circuit and Family Court of Australia. It's called Eastling and Parissa. It's a good case. It's a relocation case. Let's get into it. First, we'll start with the facts of the case. So this is a case of a relationship between Carol and Mike. Carol was age 46 and Mike was age 49. Together they had 3 children, twins who were age 10 and another child who was age 14. Now they separated in 2017 and they were both living in Melbourne, separately of course. And the father had time with the children 3 nights a fortnight and half school holidays. The children lived with their mother. Now there'd been a lot of tension and a lot of conflict between these parties since they'd separated, but they had a parenting plan and he was seeing the children 3 nights a fortnight, and the mother did say that the children loved their father. Now she had experienced significant family violence when they were together, and since separation he'd been somewhat of an asshole to her. We'll get into that a bit later. But what this case involves is Carol met a new man. Let's call him Steve. Her and Steve had started a relationship in Melbourne. They were very happy together for many years. In 2023, Steve had to move. He got a job out in country Queensland, regional town of Town B in Queensland, and he moved there. And he said to Carol, "I'd love for you and the kids to come and join me." Now, of course, she can't move to Queensland from Melbourne, which is interstate, because Mike won't let her go. She's got 3 children. He spends time with them regularly, as I said, 3 nights a fortnight. So when she asked him if she would be able to relocate the children, change states, change their housing, change their schools, he said no. So she had no choice but to fight for it. So she files an application in court seeking an order that she be permitted to move. She then said when she's living in Queensland, she will facilitate the father to spend time with the children once per month during the school term at her cost, and 8 nights during the school holidays. So a little bit more than half of the school holidays during the school year. He said no. It came before the trial judge, and the trial judge went into the case and saying whether or not these children who said they didn't want to change schools, but they wanted to live with their mother and didn't want to live with their father, they were interviewed and they had a good relationship with Steve-O. So the court had to look at all the circumstances. And whenever you're doing a relocation case as a lawyer, one of the very important questions that you're asked is, if the judge decides that she can't go, that Carol's not allowed to move to Queensland with the children, will she go anyway? Will she go and leave her kids behind so that Mike can look after the children full time and spend time with her? So, and it's always a difficult question, right? Because you don't want to give the judge an out. You don't want to give the judge an easy answer to be able to say, well, she won't go if I don't order it. So, if she stays here, then everybody can see the kids regularly. So let me show you what her barrister said when the judge asked the question of her counsel during the trial, whether or not she would go. Counsel for the mother confirmed that if I do not make orders for the children to live in Queensland, the mother would remain in Victoria and would seek orders for them to live with her and spend time with the father on a similar basis to what they do now. Because it was provided only in answer to a query as to an alternate position, I don't treat that as the proposal of the mother. She didn't actually seek that as an order. That was just in answer to a judge's question. On that basis, counsel for the father conceded that there is no need for him to consider making a coercive order requiring the mother to remain in Victoria, because she said she'd do that anyway. So I think this paints Carol as a very child-focused mother. If she wasn't allowed to go, then she wouldn't go anyway. She'd put her children first, be miserable, and stay in Melbourne so that the children wouldn't end up living with their father, who she said it would not be in their best interest to do so. So remember that in relocation cases, whether or not you make that concession. So during the trial, it became clear that Mike wasn't really a nice guy. He hadn't really been treating Carol very nice since they separated. He was somewhat of a jerk to her. And in some of the answers to questions put to him in the witness box, the judge could see his true colours. As a lawyer, that's our dream. We want the judge to see the real guy that she's complaining about. Let me show you some extracts from the judgment. So it appears that Mike couldn't help but criticise the mother and his evidence. His affidavit contains only critical comments about her, many of which are wholly irrelevant to the matters before me. For example, when alleging that the mother often went out at night, he asserts that she went drinking with her work colleagues who were several years younger than her. And again, the father's evidence during cross-examination displayed a similar focus. His hostility towards and contempt for the mother was palpable. Again, he took the opportunity to make gratuitously critical comments of no possible relevance to the children. For example, in commenting that the mother does not respect property, that her car looked like an absolute pigsty. There, you can go on to read that. Now, often we like it when witnesses give what we call an admission against interest. That is, they admit something that doesn't help their case. So the judge says, look, he did give some admissions against interest. For example, when he admitted that he once referred to the twins as little see you next Tuesday. Yeah, but he said he was only joking around. His evidence was inconsistent with most aspects of the evidence and the cross-examination. Overall, the husband's evidence appeared to be driven by grievances against the mother rather than his concerns for the children. Although the mother did struggle in cross-examination, she gave comprehensive answers to questions about matters such as her attempts to obtain detailed assessment of the child's problems. And that she didn't do what he did in the witness box, basically. The mother told the story of when the children complained to her that Dad had locked them outside for a time out. And when Dad gave the same story, he said he kind of admitted that he did that. He put them outside. The door was closed rather than locked, and the children had not been outside literally not more than 1 or 2 minutes, but he did lock them outside. The father couldn't help but take shots at the mother when he could, like digs. He sent her this email about that one time when he had their 14-year-old child in the car with them. And this is what he said in the email, that there were a number of prostitutes nearby and they were propositioned when he was in the car and the child was very shaken. He had to talk to him and educate him about that, about those type of people in the area that she lived, right? And I reported the incident to police. Mr. Eastling, that's the father. So counsel for the father cross-examined the mother extensively about this, but it backfired because the judge was like, they seemed to be having a dig at the mother in the suburb to which she had chosen to live, the suburb to which she could afford. The father was also very critical of the mother's approach to the children's safety. When these parties were together, there was significant family violence and the mother had PTSD as a result of that. And she did have psychological support since they broke up. So, but it was historical, right? They broke up in 2017. Notwithstanding that, she has a diagnosis of PTSD. The judge found in this case that the mother was subjected to significant family violence, which is a consideration in this matter. And of course, that there was hostility and distrust between them. There was no parental relationship. There was not a relationship of trust between them. So after carefully considering everything after the hearing, our trial judge decided, I'm going to let the mother go. The mother is permitted to relocate with the children to Queensland, and notwithstanding the father's complaints. And I'm also going to give the mother sole parental decision making about medical decisions that need to be made for the twins because they had some special needs. And there was so much conflict with him that they just couldn't make decisions, which was having an adverse impact on the children's well-being and welfare. So she got sole PR about medical. All the other decisions were going to be joint. Now, Mike didn't like that. He said to the judge, I don't like that decision. Get lost. I'm appealing. So he traipses off and appeals the decision for the relocation. It comes before Justice Christie in Division 1. She considers all of the evidence, the 3 grounds of appeal that he had, one of which was he thought that the mother, relying on her psychologist as a psychologist's affidavit, was improperly considered by the judge, and grounds of procedural fairness as well. The judge looked at all the appeal grounds, dismissed them all, said none of them had any merit. The judge got the decision absolutely right. So she says, get lost, Mike. I'm dismissing your appeal. Madam Carol, you're free to travel off to the sunset, to be with Steve-O, to live happily in regional Queensland with your children, away from Mike, and I uphold your orders. And you know what? Since you incurred so many costs in this appeal, Mike, I'm ordering you, where is she? I'm ordering you to pay the costs of the appeal, which were $16,000. So not only did poor Mike lose his children, he also had to pay the costs orders. So I think it was a pretty good decision. And so Carol was able to relocate with the children to regional Queensland to live happily ever after. That's the end of the story. I should say that he's still got time with the children. He's got from Thursday to Sunday every 5 weeks during the school term and significant time during the school holidays. So don't worry about poor Mike, he's still going to see his kids.